CREDAI-MCHI makes a statement that clearly the redevelopment is the way to go to provide housing for all. Even our Honorable Chief Minister has formed a special panel to promote redevelopment in our state. Now let's look at it. Since introduction of GST in 2017, the issues which have been cropped up under the GST regimes are very significant, and it has led to a viability of this entire redevelopment projects which the real estate developer actually carries on. So let's understand first what are the issues faced under the GST regime. A typical redevelopment project where the society gives the development right to a developer, and developer in turn then construct the entire building, effectively gives the area back to the existing members, tenants, and what is remaining thereafter, what we call it a free sale component, they sell in the open market. So the entire cost of redevelopment is subsumed in the free sale component which they sell to the customers. Now that free sale component which is sold to the customer effectively is liable to GST at 5%. So the first level of GST which comes up, that whenever that free sale component is sold to the customers, there is a 5% GST payable. No difficulty, because that's the transaction of supply of constructed flat to a new customer, and therefore they should pay GST at 5%. But at the same time, the law has been evolved in such a way that the transfer of development rights from society to the developer is also considered to be a transaction of supply of services, and there is a GST payable on that transfer also at 18%. That 18% is exempted only if you sell your entire free sale unit prior to OC. Otherwise, that 18% is liable to GST. In addition to that, developers are also required to pay GST when they give the units to the existing members, because that is how they are giving back the members their redeveloped, the revised new units, new flats. On that also, as per the GST law, you are required to pay 5% GST at a market value, that the value at which you are selling those free sale units. So that's the third level of GST. And the last one, that when the developer actually uses the material, the contractor, on that also there is a GST payable, which is not available as a credit or an offset to the developer. So if you look at it in a one redevelopment project, there have been multiple legs of transactions which have been exposed to GST, and the entire project is becoming unviable. The CREDAI-MCHI of the members first believe that when there is a transfer of development rights, it is an immovable property, because these are all rights arising out of land. Therefore, it is a transaction of immovable property. There should be no GST payable. Second, that when the area is handed over by the developer to the existing members, you cannot equate that equivalent to the sale price. It is not a sale of a unit. It is merely providing a construction services to the existing members. I am constructing a new flat for them. Therefore, how can you pay, or how can you ask the developer to pay a tax equivalent to as if it is a sale of a unit? So the two important concerns that developer have been raising before the Honorable GST Council, they have made lot of representations, including meeting with the various finance ministers, that please address this issue, that the development rights is nothing but a transfer of immovable property, and GST ideally should not be payable on immovable property, right? And the second, that when I give the area back to members, you cannot equate this as if it is a sale units to a independent customer. This issue has been brought to GST Council notice, and CREDAI-MCHI is thankful to the Council that they have formed a group of ministers specifically deal with the real estate